Hi, welcome to LPN's third presentation since lockdown. My name is Bharat Sota, and I'm the Secretary for Lohana Community UK. You know, when the lockdown began and the Chancellor Rishi Sunak announced the Furlough Scheme, that's the first time actually I had heard of the word furlough. And I assume I'm not the only one. I wasn't the only one at the time. As time has passed, he has also announced changes to the scheme, like, employees could be called in to work part-time and they would be classified as furloughed for the remainder of the time. He has also announced how the scheme is going to be wound up over the next few months. And during this time, we have heard in the news as well, companies laying off people, announcing redundancies. And as it's probably expected that as the furlough scheme is wound up, there very well will be more redundancies. So what are the rules around redundancies? What is the process? What are the timelines? So tonight's presentation will help clarify a lot of these points. At LPN, our objective is to bring discussions on topics of interest to our members. So if you have any suggestions, please email us on lpn@lcuk.org.uk. I will now call upon the President of LCUK, Mr. Sunil Majitia, to introduce our guest speakers for tonight. Thank you.
Hello, good evening, everyone, and welcome to Lohana Professional Network's third event during the lockdown period. Thank you for joining us. As you may all be aware that COVID-19 has forced the government to make a lot of changes to safeguard firms and their employees. One of the schemes introduced was the furlough scheme, but even this wasn't enough, as a lot of firms faced a financial crisis, which resulted in making their employees redundant. Facing redundancy is not easy to handle, and several processes have to take place and could be harrowing and stressful. We have therefore decided to bring a couple of experts to go through the processes tonight and hope they are helpful to those who need them. The speakers this evening are Pritul Khagram and Kaajal Nathwani. Pritul Khagram is an HR professional with Chartered Fellow status of the CIPD, Chartered Institute of Personal Development, and the founder and CEO of HR consultancy People Force. Kaajal Nathwani is an employment solicitor and is head of employment at a law firm, Curwens. Kaajal has supported clients by advising and guiding them on the furlough scheme and redundancy procedures, whereas Pritul has supported clients in execution of these processes. This means that our speakers today are able to talk from an employment angle and an HR point of view from both employer and employee perspective. Without further ado, I would like to hand over to both Pritul and Kaajal, who will introduce themselves.
Thank you very much, Sunil Bhai. My name is Pritul Khagram, and I'm delighted to be a speaker here today. So thank you very much to Lohana Professionals Network and also the LCUK for giving us this opportunity. So the format for this evening will be, we will go through some slides on the furlough scheme, which will then be followed by a question and answer session. Then we'll go through the redundancy slides, and that will then also be followed by a Q&A session around the redundancy procedures. So we would like to encourage you to write down your questions on the comments on Facebook, and we will endeavour to answer as many questions as possible during the session. Kaajal?
Thanks everyone. Thanks Pritul. Thank you again to LCUK and LPN for the opportunity to speak this evening. As Pritul said, we really encourage everyone to post as many questions as possible, as that's the purpose of this evening. It's an interactive session and we want everyone to get as much out of it as possible. So please do feel free to post loads of questions and we will do our best to answer them. And without further ado, I will hand over to Pritul.
Thank you. Right, so let's start off with the furlough scheme. So the official name for the scheme is the Coronavirus Job Retention Scheme, otherwise known as the furlough scheme. So let's see some background in relation to this scheme. So this scheme was introduced back in March. The government announced the introduction of the Coronavirus Retention Scheme in an effort to help employers avoid the need to make mass redundancies as a result of the impact of COVID-19. The Coronavirus Job Retention Scheme offers grants to cover a proportion of the salaries of furloughed staff. The scheme initially ran for 3 months and was backdated to the start of March. However, on the first day of operation, 140,000 companies applied to use the scheme. Following a 3-week extension of the countrywide lockdown, the scheme was extended until the end of June 2020, at which point the scheme was closed to new entrants. Later, what happened at the end of May, the scheme was further extended until the end of October, but the government had confirmed that it would end at this point. So let's take a look at some statistics. And these statistics are correct as at mid-July. We had 9.4 million jobs that were furloughed within the country. 2.5 million were within London and the South East alone, 1.4 million within both the East and West Midlands, and 1.3 million combined in Wales, Scotland, and Northern Ireland. So we had 1.2 million employers that claimed through the scheme, and these claims were worth £28.7 billion. The accommodation and food services sector were quite badly hit by this. 87% of employers furloughed at least one member of staff, and the claims from this industry alone amounted to 4.1 billion. So this gives you an idea of the scale of the scheme and the pandemic. So there are some key changes that were introduced from the beginning of July, however, and this saw the introduction of the flexible furlough scheme. Now this allows employers to bring back to work employees that have previously been furloughed for any amount of time and any shift pattern, while still being able to claim under the scheme for normal hours not worked. When claiming the scheme for furloughed hours, employers would need to report the claim for a minimum period of 1 week. Now, it's important that employers keep a record of how many hours the employees work. So, for example, if your normal hours of work is 37 hours a week, but under the flexible furlough scheme, you're actually working 15 hours. This means the 22 hours that you've been on furlough, your employer is able to claim for these hours. The scheme now is closed to new entrants, with some exceptions, such as those returning from maternity leave, for example. Okay, so now we've talked about July, but what's coming up in the next few months? So August through to October, I think it's important to understand this. So the government have applied almost a tapered approach with the aim of easing the reliance on the scheme. And so from August, the level of grant under the scheme will slowly be tapered to reflect the government's expectation that people should be returning to work. Now, furloughed employees will continue to be entitled to receive the current 80% of wages, subject to the £2,500 monthly cap, and that's through till end of October. However, from the 1st of August, whilst the government will continue to pay 80% of wages up to a cap of £2,500, employers will be required to pay employer national insurance and pension contributions for the hours their furloughed staff do not work. Then what happens in September? The government will pay 70% of the wages up to a cap of £2,187.50. The employers, however, will need to pay the 10% of wages to make up the 80% total. And again, up to the cap of 2,500. Then what happens in October? The government will pay 60% of wages up to a cap of 1,875, and employers will need to pay 20% of wages to make up the 80%, again up to the cap of 2,500. So you can see the employees will not be impacted up to the end of the scheme in terms of that. They will continue to receive 80%, but the employers will be required to contribute towards that as time goes by up to the end of October. And this is an attempt to get the economy kick-started and easing the reliance on government funding. And that's the idea around that. Okay, I'd just like to remind you that if you've got any questions, please feel free to type away on Facebook, and we'll try and answer as many of them as possible when we get onto the Q&A session shortly. Okay, so the Chancellor had a mini budget recently, earlier this month, and what are the key changes that were introduced during that budget? So first of all, the Chancellor has introduced a job retention bonus. Now, the job retention bonus allows employers to claim £1,000 for each furloughed employee that is brought back to work after the end of the scheme and until the end of January, and if that person is earning £520 per month. So the idea is that the government is giving an incentive to the employer, but is £1,000 enough? The idea is the government is trying to encourage to avoid redundancies here, but is £1,000 per employee enough for organisations to be convinced not to make these people redundant following the end of the furlough scheme at the end of October? There is also a Kickstart Scheme. So a new job creation scheme will be launched for young people aged between 16 and 24 who are on universal credit and at risk of long-term unemployment. The government will pay these workers wages for 6 months whilst they complete a job placement. The contribution will be capped at the applicable national minimum wage rate and will be available for up to 25 hours per week. So there's some opportunities here for 16 to 24-year-olds to get some employment that is essentially funded by the government for up to 6 months. So that's a really interesting move by the government. Again, the attempt is to revive the economy and make sure that there isn't mass unemployment and mass redundancies taking place. There is also the training and apprenticeships. So £32 million will be invested in the National Careers Service, with employers entitled to a payment of £2,000 for each young apprentice they take on under the age of 25, and £1,500 for each apprentice aged over 25 or over. Some £111 million will be invested to triple the number of traineeships with businesses offered £1,000 per trainee payment. This grant will be capped at 10 jobs per firm. Okay, so we will try and take some questions that are coming through. So let's just stop sharing. Right, Kaajal, are you ready for some questions coming up our way?
Indeed.
Okay, so let's see. Okay, so under the flexible furlough scheme, Kaajal, how can part-timers be treated? So if there are people that work normally part-time, how is that? How can that be treated under the furlough scheme?
So all part-time workers could have been furloughed under this scheme originally. If the employer is now in a position to start bringing those part-time workers back to the business because things are starting to pick up, then as with full-time workers who are placed on furlough, they can be asked to return to the workplace for as many hours or as many shifts or as many days as the employer needs for the running of the business itself. How they decide to bring them back, and it can be an hour on a Monday, 2 hours on a Wednesday, but what we would advise is that actually to make things more simplistic, because what will happen is the knock-on effect will be complexity in the hours claimed for via the CJRS, is that you just have like a week on, week off, or set days per week that employee is coming back for set hours, and then you can review it on a bi-weekly basis or a monthly basis.
Okay, and what about the employees that have no set hours?
Yeah, so I think what you're commonly referring to there, Pritul, is people who are engaged in a 0 hours contract. So they're sort of called up to come into work whenever the business needs require it. So for those with no set working hours, the amount of the grant that's claimed under the flexible furlough, as I said, can become more complex. Again, they can be asked to return to work as the business requires it. And then in terms of the claim and the difference between the 80% rate that was claimed when they were on full-time furlough versus when they're on flexible furlough will be calculated by reference to their average working hours pre-furlough and then an average working hours whilst they're on flexible furlough. So it can become quite complicated.
Okay. Okay. So a question here from Brane Bao. If someone is made redundant whilst on furlough, can the employer use some of the furlough payments for the notice period of the redundancy payments?
Thanks very much for that question. So yes, the furlough scheme monies can be used for the notice period, but there is a requirement for the employee to be paid 100% of their salary for any notice period. So even if you are served with notice whilst you are on furlough, you wouldn't only get the 80% rate that you are furloughed at, capped at the 2,500 and then obviously tapered down with the employer topping it up. You would be entitled to your 100% notice pay at your basic rate of salary.
Okay, yeah, thank you very much. So a question from Bhavesh Sahani. If employee is shielded and less than 2 years service, should the employer sack the employee for bad performance or furlough them?
Interesting question. So of course, if they've got less than 2 years service, employees don't have ordinary unfair dismissal rights. So ultimately, an employer doesn't have to have a fair reason in law to terminate that individual's employment, and they don't necessarily have to follow any fair procedures in order to terminate that individual's employment fairly in law. So where you're talking about bad performance, if that individual's performance has genuinely been of issue, my advice would always be to tread carefully, because the reason for the termination of that individual's employment has to be for the bad performance. If you are really wanting to get rid of that individual because they're shielding and currently on furlough and because they can't come back to work even though you need them to, because their argument is that they are shielding, you need to be very careful, because that individual could potentially have rights under the Equality Act, and for that they don't need any minimum service requirements. If they could establish in law that their condition amounts to a disability, and that's a physical or mental impairment which has a substantial effect on their ability to carry out day-to-day activities, which has lasted or is likely to last a period of 12 months or more, then they could have that protection. And if they could demonstrate that actually the reason you got rid of them was unrelated to their bad performance, but because they'd said they're not coming back because they need to shield for a bit longer, then you might run into difficulties. So complex area.
Yeah. Okay. So there's some questions coming in regarding the Kickstart scheme, which I'll go on to in a moment. But another question in relation to the 80%. So are you able to claim any other benefits when you are receiving 80%? And what about the 20%?
So with regards to the 80%, when you are receiving 80%, eligibility for any other benefits would be subject to how much that 80% is. So the usual benefits that would be available would be to those who fall under 0 hours contract, and actually they might be getting a really small amount of money. It may be that they have access to other benefits. So that would be something that you need to investigate further. And again, there'll be minimum earnings thresholds that would be used to calculate that. In relation to the 20%, I'm not sure what that's related to. Top it up, the 20%.
Yeah, so I mean, I found that employers sometimes, a lot of employers have actually topped up the 20%. And that's, I guess, a choice for the employer, the individual employer. If they want to do that, that could be seen as a benefit itself. Yeah. By the employer. I mean, I know that some organisations have just topped up as a way of saying thank you very much for coping with this situation, and also just making sure that the employees are not shortchanged during this pandemic.
Yeah, absolutely. So something that I've come across quite recently, as businesses are starting to become more operational and they're doing a cost analysis of how they've been impacted by the pandemic and how they're likely to be impacted more long term, is that they are actually, even where they haven't topped up the 20%, because they're now in a position to, they've got the money and they feel that actually our business hasn't suffered as badly as we originally forecasted, they're actually backdating payments at 10% or 20% or whatever they can, even if it's a sort of ring fence type bonus. So it's worth having that question with that question and answer session with your employer, and just sort of, either getting together as a collective or just individually and saying, look, I appreciate that you had to take the drastic measures to furlough us and cap our pay at the 80%. Have you had a sit down and think about how the business is going forward? I actually don't think you've been hit as badly as you anticipated, because some sectors haven't been, and see whether there is a potential. I always follow the mantra, if you don't ask, you don't get.
Yep, absolutely. Absolutely. So hopefully that is a question answered for you, Jitna Radia. Okay, so let's move on to some other questions that we've got. So this is in relation to the Kickstart scheme. This is from Pranay again. Am I right in that the Kickstart scheme is for new jobs created and not a replacement of existing jobs?
So there is minimal guidance available at the moment. And what I would say is keep checking the government guidance and any Treasury directives that are released. My understanding at the moment is that, yes, the Kickstart scheme is applicable to new jobs that are created. And therefore, again, we don't know how effectively all these schemes are going to be policed, the same as how furlough. We don't know how extensively HMRC will police this later on. And so where organisations effectively make individuals redundant, relabel jobs and restructure organisations, and then try and claim the Kickstart scheme for a role that was already there, there may be a potential recall of that money.
Okay, yeah, no, that's great. Okay, so really interesting question here coming up from Neha Gandhi. So with regards to the bonus scheme, so this is the bonus incentive, this is the job retention scheme. She's saying that I presume this will not stop organisations kickstarting consultations. So I imagine you're talking about redundancy consultations here in December, which could result in redundancies taking effect in around about February time. So in other words, they've kept the employee on their books till the end of January, which is what they're required to do in order to claim the bonus, and then make them announce the redundancy from February onwards. So is this some kind of loophole that potentially employers could find themselves benefiting from?
Yeah, so look, at the moment, there's nothing stopping employers to claim for the job retention bonus, get that £1,000 per employee that they get back from furlough, and then obviously making the redundancies at the point where they've, kept them on till January. What you've got to do is look at the economies of this. Larger organisations, for them, £1,000 per employee on national minimum wage, if you look at it for 6 months, £1,000 to keep someone on for 6 months is not a huge amount of money realistically. So I think very very few businesses are really going to see the merit of getting £1,000 to keep an employee on for 6 months. You know, I think you'll find that most businesses, it's a very difficult decision to make to actually get rid of staff. And it's not a decision that they're taking lightly. I routinely advise employers, and I can assure you that, you know, individuals and employers have been hit really badly by the pandemic, and they are definitely thinking and rethinking and exploring all other avenues before they make the decision to get rid of staff.
Yeah, okay. Okay, another question. So if I'm told my job is no longer there after so many years of service, do I get redundancy pay, or can they just let me go?
Yeah. So if you are told that your job is actually no longer there, then that to me intimates that it is a redundancy. Now, I'll be talking in my presentation a little bit about, you know, what satisfies the definition of a legal redundancy, because sometimes it's not called a redundancy, but actually the factual circumstances align themselves to actually it being a redundancy. So yes, if you do have long service and you're being told, well, actually, we don't need your role anymore, because that's it, it's the role that's no longer needed, it's not you personally, then yes, you would be entitled to, by law, a redundancy payout.
Okay. Good. Okay. So if an employer sacks an employee who is shielded, can the employee claim unfair dismissal or discrimination based on disability legislation?
So again, that's twofold, that question. First of all, can that employee claim unfair dismissal? Yes, ordinary unfair dismissal can be claimed if the individual has 2 complete years service. If the factual circumstances align themselves to that employee being able to show that the reason that they were dismissed was because specifically they were shielding, then the individual doesn't need to have 2 complete years service. Yes, they may have protection in law under the Equality Act if they can establish that they are disabled, in which case there potentially could be a discrimination claim. Something that most people are not aware of either is that they may potentially have a whistleblowing complaint as well, as a result of raising concerns with the employer that they don't feel that for health and safety reasons they can return to work because they are in a vulnerable category and therefore shielding. And then it would depend on how the employer managed the situation once that disclosure was raised. If the person feels that their employment was terminated because they made that disclosure, that could be a potential claim as well.
Yeah, okay. So just a general question here, is advice available from Kaajal and Pritul on an individual basis after this talk? I would say yes, absolutely. Reach out. Yeah. We're both on LinkedIn, look us up, or even Facebook. I think we're tagged on some of the notifications that went out in the LPN group and also the LCUK page as well. So feel free to reach out to us. So further questions. So if employees are on furlough leave, can they participate in disciplinary and grievance processes?
So the Treasury Directive is very clear that if an employee is on furlough, they're not allowed to do anything for the business itself. And that would include any kind of disciplinary and grievance procedures. So for managers, it's a bit different. They can participate, they shouldn't participate in it, because obviously they would be doing things to further the business by participating in any kind of grievance disciplinary procedures. With employees, if grievances and disciplinaries were instigated before furlough, and so it's a case of sort of carrying on with it, then I would say, yeah, that's fine. They can still be asked to attend meetings. Bit of a grey area, because actually ACAS guidance has suggested, although it's not mandatory to follow this, that during the pandemic, employers should think twice about initiating any kind of grievance or disciplinary procedures or continuing with them, because they appreciate that it's a very, very difficult time for everyone at the moment. And with virtual meetings and things like that, it might not be a good idea to advance any procedures and processes.
Okay, yeah, fab. All right, so one more question here. Can employers require furloughed employees to use up their annual leave, holiday entitlement during...
I wish I had £1 even for every time I ask this question. I'm sure Pritul's the same, actually. Yeah. So yes, unfortunately, yeah, employers can ask you to take annual leave during any furlough leave. And again, initially, when this whole furlough thing arose, no one really knew much about furlough. It was only a term that was used in America. No one even understood what furlough meant. And so initially, you know, employees were up in arms when they were being asked to take some of their annual leave during furlough. But unfortunately, yes, employers can ask you, usually under most contracts of employment, if you check your holiday clause, there's always an entitlement for employers to be able to ask employees to take holiday when they want. And even if there isn't, under the Working Time Directive, they can ask employees to take leave when they want them to, as long as they give the requisite notice, which is double the period of the leave that they're asking you to take. So yes, they can. Think about the benefits. If you're taking annual leave during furlough, you're potentially getting 100% of your salary, as you should be under your contract, instead of any capped rate at 80%. But again, I would maintain an open dialogue with your employer. Understand why they're asking you to take it. And if you genuinely can't take that leave during furlough because, for example, you're caring for dependents or those that are shielding, you've got no intentional ability to go away, you've got your kids at home, then have a conversation, because all employers that I'm advising, I'm saying, look, keep an open mind and keep talking to your employees, because every single person is in a different situation at the moment.
Yeah, I mean, yeah, so looking at it from an employer's point of view, if you've got someone on furlough for, let's say, 6 months, and during that time, obviously, they are accumulating annual leave entitlement. So can you imagine if these employees are all returning at the end of October following the end of the scheme, and then they all return and book annual leave, of all their entitled annual leave? It can be disastrous for the employer at that point in time. Yeah. Therefore, I think it's a bit of it's a two-way thing, really. The employee's got to understand that actually for the business who has furloughed me all this time, and, you know, I've pretty much been sitting at home being paid my 80% of my salary. So therefore, yes, why not use up some of my entitlement during this time? It will help the employer, and at least when we all go back to work following the end of the scheme, it will be helpful, and it will help the economy as well and the employer. So it's a bit of both ways.
I agree. And I think actually for any employers that are asking employees to take annual leave now, employees are less up in arms than they were when lockdown was first initiated, because measures have been, lockdown measures have been relaxed. You can actually travel. There are less travel restrictions in place even to go abroad. Some of the quarantine periods that were potentially going to be there aren't there, so you can go to some countries and not have to worry about that. So I certainly think that if you are asking from the employer's perspective, that right now is quite a good time to ask, because I think actually lots of people are itching to take some time off, because they've either been putting in loads of hours, with their children and family and whatever, even whilst they've been on furlough. So definitely worth, as Pritul said, maintaining an open dialogue with them. The law has actually been temporarily changed to allow employees to carry over holiday into the next 2 holiday years. So as I said, if you've got a particular employee who for whatever reason says, look, I absolutely can't and I really don't want to take it, have a chat with them. It might be that you can stagger their leave so you haven't got everyone taking all the leave as soon as they're due to come back to work.
And also just covering the point on the notice. So the employer needs to give the notice, right? So if the employer needs you to take annual leave, if, for example, they've asked you to take, I don't know, five days of annual leave, they've got to give you 10 days notice in order for you to take those 5 days. So those are things to bear in mind. They can't just say you're on annual leave, you take annual leave from tomorrow. They've got to give you some notice. This allows you to plan your time off and enjoy time with family or whatever it may be. Okay, so we're going to take one last question on furlough before we move over to the redundancy side of this presentation. So can managers, so this is a question from Priti Jobanputra, can managers conduct consultation meetings whilst on furlough?
So again, a little bit of a grey area. I would say they probably can't, because that's to do with the business and it's integral to the business. So ideally, if you are on furlough, you shouldn't really be asked to be conducting any kind of consultation meetings. Now that flexible furlough is in place, it may be that actually the thing that you need to be saying, if you've been asked to do that, is actually I should be brought back for 2 days this week to do the consultation meetings. I don't know if Pritul's views differ.
Yeah, no, I absolutely agree with that. Because of the flexible furlough scheme, if this question was asked at the end of June, then definitely it will be a case of, well, no, you've got to bring them back off furlough. And when you bring people back off furlough, well, and then you could have in June brought people back off furlough for a few days and then put them back on furlough. But the requirement was that they had to be put back on furlough for a minimum of 3 weeks. So this is why the flexible furlough scheme gives exactly that, more flexibility to the employer. So I would say that that's now the case, given that we've passed June already. Okay. The other thing I think, Kaajal, you've alluded on this as well quite a bit, in that this furlough scheme is new. It's brand new territory, even for you and I, who have been working in the industry, in HR and employment law industry for a long time. This is new. So we're also learning as we go on. You know, we're coming across new scenarios, new questions all the time, and there isn't a model answer to all of them. You know, things take absolutely ages to become legislation, so that we're only going by what is the direction from the government given, and then applying kind of common sense, some reasonableness, and you know, employment law general practices in answering certain questions and advice. And so I think that's important to note here.
I think that's absolutely right. And as Pritul said, you know, we don't know ourselves sometimes. And it's really poignant, actually, that when Boris Johnson, first of all, announced that, you know, those who should work from home should stay working from home, but those who work in industries that, you know, had no choice but to sort of start going back to work, then they should. And someone actually asked the question, well, what if my kids are still at home? Because obviously only reception year 1 and year 6 have gone back. What happens then? And he kind of paused for a second and said, well, you know, that's where you need to be talking to your employer. And we would hope that employers would exercise the discretion to allow you to either remain on furlough or, if you can at all, work from home. And that's the thing. They don't know themselves.
Don't know. Yeah.
And that's the thing. That's why I keep saying this thing about keep an open dialogue. You know, make sure that the employer and the employee, both of you, don't get entrenched in your positions. Keep an open conversation going as circumstances change.
Exactly. Okay, so let's move on now to the redundancy part of this presentation. So I'd encourage everybody to continue asking questions. We have saved some of the redundancy related questions to answer them when we come on to the redundancy Q&A. But when we come on to the redundancy Q&A, if you think you've got some furlough related questions as well, feel free to ask them at that time as well. We've got until 9:30, which is when we will wrap up. So over to you, Kaajal, to share your slides with respect.
Thanks, Pritul. Perfect. Okay, so I'm going to be going through a whistle-stop tour of what is redundancy and the process that should be followed. So this is relevant to whether you own a business, or from an employer's perspective, you know what it is that you need to be doing, or whether from an individual perspective and you are currently facing a redundancy scenario at work and you want to make sure whether or not they are following the proper process. So what is a redundancy? It's either closure of the business as a whole, permanent or temporary, closure of the particular workplace where the employee is employed, and that is even if there is a mobility clause. Now, what a mobility clause is that clause that you commonly find in contracts saying, or a location that is deemed reasonable from time to time, or something like that. So it's commonly found in the hospitality sector, where, for example, somebody may be based at one particular branch of a restaurant, or even in retail, but if business requirements require it, they can be asked to go to a different location. But redundancy would still apply if their particular branch of the shop or restaurant or office was to close, even if there were other offices or restaurants or any other locations available for them to work. Or 3, reduction in the size of the workforce. So that is, the requirements of the business change, or fewer people are needed to carry out work of a particular kind. The redundancies have unfortunately increased most recently as the furlough scheme is starting to come to an end and as the tapering is brought in. The coronavirus pandemic has detrimentally impacted the UK economy, with no sector really remaining unscathed, although Pritul did say that the food and leisure and hospitality sectors have been most hit. More than 100,000 job cuts are expected during the pandemic, and that's just a tentative figure. I expect that's going to be a lot more. The coronavirus job retention scheme itself, as Pritul mentioned, has allowed millions of people to stay in a job. But as those contributions to the scheme come in, many may have no job to return to because businesses are doing a cost analysis and seeing, whether they really can sustain contributions of an additional 10% and 20% in September and October, not to mention the contributions of NI and pension contributions, which will come in August. So it's reported that 1 in 3 employers will make redundancies in the coming months to ensure their business survives the global impact of the pandemic. As an employment lawyer, last month and this month have been the most busy for me that I've ever seen in my career. And the reason for that is, as I said, businesses are undertaking analysis of and forecasts of the future and actually determining, a lot of employees who've been on furlough, we actually don't need them. We actually can't sustain them coming back to work. So the value of having a redundancy plan. Why businesses should have a redundancy plan before they kickstart any process is because it means that everything will go as seamless as possible in this tenuous situation. It helps you manage each stage of the process and even avoid compulsory redundancies. So again, my favourite thing is maintaining an open dialogue with employees, because you may well get some employees who've been waiting for the kind of opportunity such as redundancy, and they may well apply for redundancy on a voluntary basis. So what is a redundancy plan? Effectively, it's a consultation process. You then select staff for redundancy after the fair and reasonable process. Now, fairness and reasonableness is the mantra in employment law. You then give staff notice in writing in accordance with their contract or statutory entitlements. You work out what they're entitled to by way of redundancy pay, and then you support staff and plan for the future. So how do we ensure that we get the consultation process right, especially during COVID-19, where there's the additional sensitivities of individuals facing very difficult circumstances, even more so than they would ordinarily in a redundancy situation? Sit down. This can be remote. There's no legal requirement, despite many misconceptions, for face-to-face meetings with employees or their representatives if there is a collective exercise. Explain the planned changes and obtain feedback from employees and their input. That's the concept of consultation. It is a two-way process. It's not for an employer to just sit down and spout out what they're intending to do and then say to the employees, well, that's it, the decision's made. The whole point of a consultation is that there is no decision as yet. It is a conversation that you are having with your employees and obtain their feedback as to potential alternatives. Something that you need to be mindful of is that if there are 20 or more employees at the same workplace being made redundant within 90 days, there is an obligation to collectively consult. Now, what collective consultation is that because of the sheer volume of people that are going to be impacted, employee representatives are elected, and effectively the employer will consult with the representatives who then filter the information through to all those who have been placed at risk. Despite collective consultation obligations, there's also a requirement for individuals to be consulted. Again, that's sometimes a step that many large employers fail to implement. Despite collectively consulting with employee forums or even the representatives, there is still a requirement to have a meeting on individual basis with anyone who is placed at risk. This allows an opportunity for the employer to discuss the planned changes with the individual affected employee. And that, I've said here, can include employees who are not actually losing their jobs. Now, again, that's quite important. It's not only those individuals whose roles have been placed at risk that need to be consulted with, but perhaps those whose scope of their role is going to change as a result of various other job cuts. Or it could be that, for example, a restructure exercise means that, the title or their reporting lines change. So they also need to be consulted in this change in your business. Plans must not be finalised at the consultation stage, and the aim is to include any employee's suggestions or ideas. There are no set rules for consultation. So this is something that I'm asked frequently. Can you tell me exactly what I need to do? Can you tell me how many meetings I need to have? Now, this depends on the size and administrative resources of the employer as to how many consultation meetings you have, how spaced out they are, over what period of time they are. The overarching aim of a consultation process is to show that the consultation was not only genuine, but that you aimed to reach agreement by listening to employees and that you responded to questions and suggestions fairly. So what information do you need to provide as an employer? And if you are an employee faced by this situation, what information should the employer have provided to you? First of all, you need to know why they are making redundancies, the number of employees and which jobs are at risk, how employees will be selected for redundancy, so what selection criteria will be applied. Weighting. Now, this is important because although there might be, for example, 5 selection criteria that each affected employee is scored against, if one of those criteria is particularly important, more so to your business, you can weight that criteria. So that has an enhanced outcome in terms of the scores. How you plan to carry out the redundancies, including the timeframes, and these can be broad estimates, and how you will calculate redundancy pay. Is it just the statutory formula that will be applied, or are you providing an enhanced redundancy payout? And if you are using agency workers in the business, how many are going to be affected, where they're working, and the type of work that they are doing? So it's advised that generally consultation meetings should take place over a 3 to 4 week period and should be about 2 to 3 meetings at a minimum. That would generally be my advice. And the consultation meetings would focus on ways that you as a business could avoid or reduce the number of redundancies, how to reduce the impact of the redundancies on a wider scale throughout your business, how you can restructure or plan for the future to avoid the redundancies, how you've selected those employees for redundancy. So I refer again to any selection criteria or matrix or weighting applied, and to consider and respond to any suggestions made by employees. Okay, you can reject any suggestions made by employees, that's fine, but you do have to give a reasonable reason and explanation as to why you feel that any alternative suggestions just aren't feasible for your business. Please document all discussions and the reasons for your decisions, and that's twofold. So as an employer, make sure you make notes of everything and provide notes to the employee after every meeting. And as an employee as well, please make sure that you take notes during any meeting so that there is an accurate record and that you can contest any kind of minutes that are then provided if they don't accurately reflect your recollection of what was said. Make sure the right level of detail is provided so that staff understand properly what it is that you're intending to do. Please, as an employer, don't shroud them in any kind of business jargon that they're not going to understand as to the reason why you feel there's no option but to make redundancies. How do you select employees for redundancy and make sure that you are not going to be caught out on the wrong side of an employment tribunal claim for an allegation of unfair selection? Again, fair and reasonable is the mantra. Use objective selection criteria. Now, what do I mean by that? Standard of work, skills, qualifications, experience, these are all objective. Please make sure that if you are using something like attendance record, that it has to be accurate and must not include any absences relating to any disability, pregnancy or maternity. And again, you must not select employees. Again, it seems as though an obvious thing to say, but please make sure that if you are a business owner and you are going through a redundancy exercise, that you are not swayed by considering getting rid of someone because of their age, race, sex, disability, or any of the protected characteristics under the Equality Act. During the pandemic, you must also not select employees for redundancy just because they're shielding. So again, this is something that is likely to come up in the Q&A session because this could amount to disability discrimination. I've put down here maternity protection under Regulation 10. This is something that is not commonly known. You must be careful if you place an individual who is currently on maternity leave at risk of redundancy, because they are automatically protected by something known as Regulation 10 of the Maternity and Paternity Regulations, which means that they have the first right of refusal in relation to a suitable alternative. They automatically have to be put forward for a suitable alternative and be offered one if there is one available. So what's suitable? We talk about suitable alternatives and the employer's obligation to consider suitable alternatives. As an employer, you need to make sure that you explore any alternative roles in the business, and these must be offered before the old job ends and start within 4 weeks at the end of the previous employment. You can have a competitive selection process. This is something that I get asked all the time. There's a suitable alternative, but my employer hasn't offered it to me automatically. They don't have to. It's up to an employer whether they want to engage in a competitive selection process or invite you for interview or make you apply for the job formally. There can be a 4-week statutory trial period, so you might decide that you want to go for a suitable alternative, but your concern is that actually, I don't know if that's the right role for me, I'm not sure I'll like it. Well, you're allowed a 4-week trial period, and then you can turn around and say, no, it's not for me, and you're still entitled to your redundancy pay if you decide that that suitable alternative isn't for you. It's for the employer to prove that any offer was suitable and refusal was unreasonable. Now, the reason I say that is because you can refuse a suitable alternative if you think it's unreasonable. I'm coming up across this a lot at the moment, whereby suitable alternatives are being proposed by employers at sort of 10, 15, 20,000 less than what the individual was employed on by way of salary right now. Employees are turning around saying that's really unreasonable. Employers' position is no, due to the pandemic, it's completely reasonable because actually the job market's really bad, so you should be thinking about this. It's for the employer to prove the offer was suitable and any refusal was unreasonable. We're almost there. So you've got to the end of considering any suitable alternatives after you've gone through a collective exercise or an individual consultation process, whichever is applicable. You've thought of every other suitable alternative to avoid redundancy, and you've come to the conclusion that there is no other option for your business other than to serve notice of termination. This must be in writing and must clearly set out the reason for the termination of employment. This is a legal right of the employee to receive written reason for dismissal, because it is effectively a dismissal in law, although we don't like to use that word. It is a dismissal even if it's for redundancy. And please, as an employer, set out in that letter what your intention is going forward. Are you going to want to get that employee to work their notice period? If they're on furlough, that might be that they stay on furlough, so make it very clear. Set out what their redundancy pay entitlement is, and any other paid payments that they're owed, I should say holiday, it might be other bonus or accrued commission, etc., and set out when they're going to receive that. Allow the opportunity to appeal against the decision. So this is important, and this is something that's quite frequently missed out by employers sending letters of notice of termination. An employee is entitled to appeal against the decision to dismiss, so it is important to make sure they're provided with that right. You'll find that many employees, if they are made redundant, are unlikely to appeal against the decision, but it is something that should be put in the letter. And it may be that you consider a settlement or compromise agreement, as it was previously known, as a safeguard. So, for example, if you think that an employee is going to potentially kick up a fuss as a result of being selected for redundancy, you may wish to consider safeguarding your business against any potential dispute arising as a result and offer them a settlement agreement. It's quite commonplace in redundancy and restructure scenarios. And because you are advancing a payment to that individual for their redundancy entitlement and quite often notice pay and holiday pay, etc., all this is set out in a contractual document, which they sign, you sign, and they get advice independently from a lawyer. And that will safeguard you against any claims from them in the future. So, quick summary here. A dismissal for redundancy may be unfair under general principles for one or more of the following reasons. So this is what you need to bear in mind before you make a decision to go through any kind of redundancy process. Is there a genuine redundancy situation being faced by your business? If there is, that's fine. That's okay to go through a redundancy exercise. Make sure you consult appropriately, because a failure to consult adequately can render the process unfair. Make sure you select employees fairly using objective criteria, and make sure you consider offers of suitable alternative employment or an opportunity for individuals to apply for any suitable alternative employment. Just something to note, an employment tribunal, if you are a business owner, will never challenge the business or the economic decision that you took to make redundancies, okay? That is entirely up to you as a business. You can make the decision that you need fewer people to conduct work of a particular kind. The tribunal will not challenge you on that. What they will challenge you is on those A to D points above, and that's the process. So an alternative to initiating a redundancy exercise, and it's often the quicker option if you don't want to wait 2 to 3 weeks. And remember, as a business, you might want to make quick decisions because of the tapering down of the Coronavirus Job Retention Scheme grant that's available, is to initiate a protected conversation under Section 111A of the Employment Rights Act. And that is to basically have a conversation with the employee, tell them that they are likely to face a redundancy process, but to avoid going through a 3-4 week process of multiple meetings and the whole rigmarole that comes with it, you are offering an opportunity for a quicker resolution under a settlement agreement. And it may be that you have to incentivize the employee and chuck in an extra couple of weeks pay, for example, but that is an option available and something that we are seeing very, very much at the moment. And that brings my presentation to an end. So I think we're going to jump into the Q&As now.
That's right. Okay. So thank you very much for that, Kaajal. We've had quite a lot of questions come through. So I'll just take them in probably the order in which we've received them. Okay, so a question from a Ritesh Gakani. If I offer redundancy to an employee, can they object to it? And what is the best way to deal with that?
So when you say offer redundancy, I presume that you're basically going to have a conversation with them and offer them a redundancy pay, whatever they're entitled to. They can object to that and they can reject that in favour of you going through a proper and fair process, because presumably they will be pitched against other people in any kind of selection exercise. And then as a result of that, you know, take their chance because they might not necessarily be selected. If you've gone through a process and their role is made redundant, they can't object because the decision is yours. They can appeal, and that is the right of appeal against dismissal. And then you would have to hear their appeal. If you were instrumental and you actually were the person who made the decision to terminate for redundancy, it should be somebody else in the business who hears the appeal. And that appeal would commonly comprise of all their arguments why they feel it was really unfair that they were made redundant, whether it's because of the criteria or there wasn't a redundancy. We don't know what they're going to say, but that appeal should be heard. And then after the outcome of the appeal, there's no further right of appeal. It would go, if they want to, they could bring a claim in the tribunal.
Yeah, I suppose the important point there is that you're not actually making a person redundant, you're making a job redundant. And so if there are other people sharing the same job, they're also in the same pool as part of the selection criteria. So you're making jobs redundant as opposed to people.
And that's a real common misconception. You know, people say, oh, you know, I've been selected for redundancy. Yes, that's true, but it's the role itself. And that's what we say when we're advising employers. It's really important that you look at it in the round, in the structure of your company and the roles specifically, and don't please be sort of jaded by selecting individuals due to various other reasons unrelated to that role not being required anymore.
Okay. All right, so another, here's a question here in relation to redundancy pay. So this is from someone that has been a long-term employee for 20 years plus. Are employers obligated to pay full weekly basic rate when calculating redundancy pay, or do they just have to pay the capped amount of £532?
Really, really disappointing answer for you. And they are not obliged to pay your actual weekly rate of pay. They are only obliged to pay the weekly capped rate at the statutory limits. Again, if you've got extremely long service, I would say have a conversation with your employer, because it may be there is some room for negotiation as a result of your long service. Again, that's something that we commonly advise on. It may be that you are offered X, and then you can sort of have a conversation with your employer to say, look, in light of COVID, in light of my length of service, you know, it's unlikely that I'm going to find another job for X number of months. Can you think of uplifting the sums that are offered to me?
Okay, yeah, thank you. So another question here: if the employee receives a redundancy payment of over £30,000, sorry, can they contribute the taxable portion into their pension pot? In this particular situation, the employer is not agreeing to transfer the amount to the pension pot. So this is a question from Deepika Hindocha.
Yeah, thanks, Deepika. So yeah, you're quite right. Under any kind of severance package, the first £30,000 is tax-free, as long as none of those monies are disguised bonus payments, commission payments, or pile-on payments. That's payment in lieu of notice payments, and therefore are not taxable, and it is purely compensation for lost earnings or redundancy pay. Now, you can pay anything over 30,000 into a pension fund. Employers should be quite flexible about that. And what you need to be mindful of is, although you're not taxed on that when you pay in, you might be taxed on it if you hit a threshold when you withdraw from the pension or you draw down on the pension. So for that, you'd have to get some specialist pension advice.
Okay. A question in relation to voluntary redundancy. So this is from Pranay. If someone applies for voluntary redundancy, can you confirm that an employer has the right to turn down the request?
Yeah, so what I would say is that you look to your own company's policies and procedures in relation to voluntary redundancy applications. Just because you apply for voluntary redundancy, even if you satisfy eligibility criteria to make an application, ultimately the decision usually rests with the business. They can turn around and say no. Again, in any voluntary redundancy applications, you need to remember that they will have determined roles that are at risk or no longer required in the business, and they may get double the number of applicants compared to the roles they want to cut. And so they don't have to say yes to everybody who wants to take voluntary redundancy.
Okay, great. Another question from Anamit Ganatra. If you are still employed, can your employer refuse you an annual pay increase?
So it's very uncommon for there to be a contractual right to any salary increases. I'm yet to come across any contracts of employment at any level, whether it's sort of very, very senior or junior, which automatically entitles you a contractual right to a salary review and therefore an increase. Often you'll find clauses that say your salaries will be reviewed annually, but there will be no right to any salary increase. So yes, even if you're still employed, whether you're on furlough or not or whatever, there's no right to an increase usually. Check your contract, that's what I would say.
Okay. So there's a question here in relation to, can I look for a new job whilst going through the redundancy process? And the second part really to that question is, if whilst going through the redundancy process, I was successful in obtaining a new job, is the employer required to give a written reference when I leave the organisation, especially if the company is closing down?
Yeah. So whilst you're going through a redundancy exercise, employers are asked to be mindful of being flexible where employees want to go to interviews and look for other jobs, whether that's internally or externally. If you are ultimately successful in finding another job, then usually as part of any kind of redundancy process, they do confirm that they will give a standard format reference, which is pretty much all you get these days with companies agreeing to reference this sort of start date, end date, and the job or the position that you're employed in. They don't give much more than that. And it's basically to tally up whatever you're saying on your CV and dot the I's and cross the T's. What I would say, if the company is closing down, then, you know, you would really just put down your line manager if you had a good relationship with them, and they would be the personal referee and they could attest for your actual skill set itself. If a company's closed down, then your future employer would have P60s in order to be able to align your employment history for dates tally up. So I wouldn't worry too much about that.
Okay. Okay, can you put on gardening leave for a period after being made redundant? A question from Stuart Goff.
Yes, so garden leave, for those of you who don't know, is where you are ultimately told by your employer that you remain employed by them, and it's usually applicable through a period of notice, that you're still employed by them. They've served you with notice to terminate, and whilst you serve your notice period, you're put on garden leave. So you're not required to come into work. You're usually not given access to any of the business systems because you are either not required in the business or you present a risk to the business in terms of taking confidential information or contacting their key clients, customers, suppliers. So yes, you usually can be put on garden leave. Check your contract. If there is no garden leave clause in your contract, then potentially you can argue against your employer if they try and put you on garden leave because there's no contractual right there. But to be honest, most people are happy to be placed on garden leave because you're getting paid to stay at home.
Okay, great. Okay, a question in relation to pay cuts. So can employers enforce a pay cut across all staff, so across the whole organisation, in an attempt to avoid redundancies?
Yes, they can. So in order to implement a pay cut across the board, that is a variation to your contractual terms because your salary is a contractual entitlement. They can't unilaterally vary your contracts. They can't just do it without telling you. It's quite commonplace at the moment due to the pandemic for employers to be taking this measure to avoid widespread job cuts. What they would have to do is adequately consult with you. In reality, you know, it doesn't require extensive consultation because most people are happy with a sort of big Zoom meeting whereby an announcement is made by the CEO that, look, to make job cuts, we're going to have to cut everyone's salary by 10% across the board. If anybody objects, they can, but by objecting, essentially what you're saying is that you're not accepting your new terms and conditions of employment. And then you've got two options. You either resign because you don't want to work for less money, or you're effectively accepting those terms under protest, which again opens a other whole can of worms, which is, you know, you could claim for breach of contract and then for the difference in pay and you know, but yeah, they can, is the short answer.
Brilliant. Okay, so not redundancy as such. Another question from Jitna Aradhya. More general kind of employment law question. If you are a full-time worker and the employer asks you to cut your hours down, are you in a position to refuse that? Can you refuse that?
So really similar to the previous question, because again, that would amount to a contractual change. It's a reduction of your working hours. Yes, if you refuse that, then you are basically leaving yourself in the position where the employer will turn around and say, well, it's a take it or leave it situation for us. By refusing that reduction in hours, are you then tendering a resignation, or are you then accepting that under protest? And again, a similar concept would apply. What I would say is that if you are being asked to reduce your hours, find out whether anybody else in a similar or comparable position to yourself is also being treated the same, and is there any reason for any differential treatment if they are not, because that could be an avenue to try and negotiate with your employer.
Okay. All right, so here's now a nice question that crosses two subject areas, so TUPE and redundancy. So I hope you're ready for this one. So if you are TUPE'd across from one company to another, is there a cooling off period before which you can be selected for redundancy with the new employer? And I believe that's the question from Paresh Raja.
Thanks, Paresh. You're not being kind, are you, for like 9 o'clock in the evening and asking TUPE questions? Yeah, so there isn't a technical cooling off period. TUPE is a really sort of grey area of law again. It largely relies on a lot of case law. The premise here is that even if you are transferred over from one business to another, if you are ultimately made redundant and you can establish that the redundancy was in connection with the transfer, then that would be an automatically unfair dismissal. Now, how sufficiently proximate to the date of transfer does a dismissal or a termination of employment for reasons relating to redundancy have to be in order for it to be deemed inextricably linked to the transfer itself? That's the question. So, if you're talking about being made redundant in a year's time, it's arguable that it's nothing to do with the transfer. That was a whole year ago. It's nothing to do with it. It's usually where the redundancies take place sort of in quite quick succession after the transfer that you can establish that causal link between the transfer and the decision to terminate itself. It also depends on a lot of other surrounding circumstances, i.e., whether there were doubling up of jobs. That sort of strengthens your argument that your redundancy was blatantly because you came over from a company where there were a doubling up of jobs when you joined the new company. So various factors to consider. There's no specific cooling off period then.
Okay, fab. Thanks. Hopefully that answered your question, Barish. Right. Should my employer help me find other work?
Yeah, so, as an employer, you've got to act fairly and reasonably. So yes, I would say as an employer, you should help to find another job, whether that's internally or externally with a third party. And that would be allowing reasonable time off to prepare for interviews, providing any kind of support or training to upskill employees, whether it's, for example, providing access to any kind of training platforms that you might have to make that person more marketable going out. And I would say that, that's really something to consider, especially for long-standing employees, career employees who've been with you for 10, 15, 20 years, who are really going to have to go out there and foray into a job market that's really unfamiliar to them.
Brilliant. Okay. And so you talked about earlier that employers are required to find reasonable alternative employment, and that's really within the organisation. So the question is, what is reasonable alternative?
Yeah. Employment lawyers and employment specialists love this whole concept of reasonableness, and it's not really very objective at all, really. So what is reasonable? It depends. It depends on the seniority of the position, the qualifications required for the position, the salary of the position, location of the position, hours, all those things that are benchmarks that made you accept the job that is now being made redundant in comparison to the newly proposed suitable alternative. Because if that new suitable alternative is not anywhere near aligned to the job that you already have that's being made redundant, then the argument is it's not suitable, because it's nowhere near the job that you originally accepted.
Okay. Another question here regarding redundancy pay. So how does accepting reduced working hours or pay affect my redundancy payment later on?
Yeah, so this is a question that we're being asked all the time, because what's happened here is that employers have taken various COVID-related measures, irrespective of furlough. For example, reducing hours, because again, they've done a forecast of their business going forward and decided that, especially in the travel sector, for example, they don't expect to get back up to speed where they were pre-pandemic for another 18 months. So they've slashed working hours and consequentially salaries. So if reduced working hours are accepted as your normal working week, and this is a permanent change, then any kind of redundancy pay or entitlement would be reflective of the newly reduced hours and pay. Where it becomes a bit of a grey area is whether, if you've accepted that change as temporary, and is it temporary with an end stop? So if it's temporary for a 2-month period, and you're made redundant after that 2-month period, then you can say, well, no, I'm entitled to my redundancy pay and any entitlements that flow from that at my ordinary contractual rate, which was pre-reduction. But if there's no end date to this reduced hours, then it's arguable that if you're made redundant whilst working these reduced hours, which were going to continue until the business thought it was okay to increase them, which could be for a year, 18 months, then it would be at the reduced hours, arguably.
So that's a bit of a bummer, really, for someone that's worked for a long time for an organisation at full-time hours, let's say, and then reduced down kind of permanently to a lower amount. It's basically the lower amount that will be calculated in redundancy pay calculations. So it's important that you consider that, I think, very carefully when you are accepting reduced pay. Take your length of service into account and the likelihood of you being made redundant going forwards. And you might be able to assess that based on the direction the business is going or other means. Okay, so can I be made redundant if I'm on sick leave?
So yeah, if an employer decides to make you redundant whilst you're on sick leave, you may qualify to bring a claim from fair dismissal if you satisfy, again, the requirements under the Equality Act. They don't, they can make you redundant whilst you're on sick leave is the answer to that question in a nutshell, but it's why you're on sick leave, which makes a difference. And they still need to adequately consult with you whilst you're on sick leave and not treat you any differently to anybody else that they are consulting with. But it rather depends why you are sick. Is it long-term, short-term? Is it because of a potential disability? And then a few other questions may arise out of that.
Yeah, I suppose a follow-up question to that is, can I be made redundant? Can employees be made redundant if they're on maternity leave?
Yeah. So as I said before, yes, employees can be made redundant if they are on maternity leave. There's nothing to stop you. You still have to adequately consult with them and go through the various hoops that you have to in order to effect a fair and reasonable process. Where the red herring comes in is where the suitable alternatives are considered, because if there are any suitable alternatives across the organisation, you automatically have to offer that person on maternity leave the suitable alternative. That is probably the one time in law that preferential treatment is given to somebody over anybody else.
Yeah, okay. Good, okay, so another one, how much notice are employees entitled to?
Yeah, so for what notice you're entitled to if you are made redundant, first of all, check your contract of employment. That will set out what notice an employer is required to give you if they choose to terminate your employment for whatever reason, and for what, redundancy is a reason for dismissal. Now, the default statutory provisions are that an employer is required to give at least 1 complete week's notice for every complete year's service. So if you've got 1 year's service, 1 week's notice, 2 years service, 2 weeks notice, and all of that is up to a maximum of 12 weeks. So the maximum statutory notice that an employer ever has to give is 12 weeks, and that would be for somebody who's been there for 12 years. A lot of positions may automatically have 3-month notice periods, and they are sort of, positions are more difficult to recruit for example, but always check your contract. There are some positions that have 6 months notice, chefs, for example, quite commonly have 6 months notice, because it's quite difficult to recruit for positions, but always check your contract.
Okay, so let's say someone has worked for 15 years for an organisation. They will be entitled to 12 weeks pay because it's capped at 12 years of service,
Right.
week of pay per year of service. On top of that, can they get their contractual notice as well, or is that within the 12 months?
It's within, so it's within the 12 months. So it's not a case of by law you get 1 week for every year and then you also get your contractual notice. It's whichever, if you've got a contract, you go by the contract. If the contract doesn't set out the statutory minimum, because some old contracts actually aren't drafted correctly, then it's the statutory provisions that protect you, and at a minimum you would always get 1 week for every year, up to a maximum of 12 weeks.
Okay, fab. So I think that's all the redundancy related questions. We do have a few more questions from the on the furlough side again, which came up a little bit later on. So we'll just touch on those. We've got a few more minutes, so if anyone's got any further redundancy related questions, feel free to put them on the group. But the furlough question is that there was a recent case where somebody in the Midlands is being taken to court for furlough fraud. If an employer claims furlough money and continues to ask staff to work, how long do HMRC have to investigate these issues?
Furlough fraud, something that is a completely new concept. When the scheme was launched back in March, it was made very clear that furlough fraud would not be tolerated, and there would be a mechanism put in place to audit those companies that are claiming for furlough funds. How this is being policed, how long they will have to be able to investigate and ask for audits, we don't know at the moment. At the moment, what the revenue are doing is where they are tipped off on furlough fraud. I think those companies are taking priority and they're the ones that are being investigated. But the speculation is that there will be random audits, and it will probably be a selection of each sort of number of furlough claims per business that have been made. Something that is really important to note is a lot of the large organisations, because they're concerned about the audit that's going to take place and the thresholds that are going to be used in the audit, and they might be found that they actually could have afforded to pay these employees, are already paying it back.
Yeah. Yeah, I suppose with the flexible furlough scheme now in place, there is this requirement to keep a record of the time an employee has worked versus the hours that they are furloughed. I believe there is a requirement to keep a record of that at least for 6 years.
6 years, yeah, that's right.
So you'd think that to answer this question just before this, that you know the HMRC could investigate up to 6 years in the future. Whether they would have the manpower to do this level of carry out the volume of investigations is another question altogether. So, yeah, my suggestion would be play by the books, because if you get caught, that could be disastrous.
Definitely. And I think that goes across the board, doesn't it, Pritul? Even for the job retention bonus, for anything that you're claiming, you know, play by the books and keep all records as well for a minimum period of 6 years. And then when you get to that 6-year point, hopefully we'll have some more guidance and more legislation to say there is a specific requirement to keep all this for X number more years, because the audit's going to go on for however. So, yeah.
I mean, there's always ways in which this scheme can be misused. I mean, we had an organisation that had someone on sick leave, and there was no sick leave policy, so statutory sick pay applied. So instead, what they did is they put them on furlough, so they're able to claim furlough grant and pay the employee that way. I guess that's an example of how the scheme has been misused, and you know those types of things could come back and bite the employer quite hard later on. So, okay. Another question: Do employers have to give notice to bring you back from furlough? If so, how long? This is from Rishi Raja.
Thanks, Rishi. So I would check any furlough agreement that you've entered into with your employer, because most furlough agreements that I've drafted, we've put in a bespoke notice clause in there to say that we will give you 1 week's notice before we decide to make any decision to bring you back from furlough, because there's a general acceptance that whilst on furlough, people have got other responsibilities, for example, family, children, etc. So check your furlough agreement. Again, this whole concept of reasonableness. So we would say to employers that they should be reasonable, and employees should be reasonable as well in terms of what their expectation is. You know, again, grey area, when we have the announcement from the Prime Minister that, you know, the construction industry, etc., could go back. That announcement was made, I think it was on a Sunday evening, and he said that, you know, employees should phone their employers. Well, what were they supposed to do on a Sunday evening? Phone their employer and say, right, I'm off furlough from tomorrow, am I? It doesn't work in practice. So again, you know, speak to your employer. If they say to you, you're due back in a week, if that doesn't work for you, have a conversation with them. It could be that your kids are still home from school, they're not due, you know, you can't come back till September. Maintain an open dialogue.
Okay, I think the last question, and this is going back to redundancies, is redundancy pay capped?
Yes, it is capped. So there's an upper limit. Forgive me, I don't know the figure off the top of my head because the statutory limits have just been increased. But Pritul, you might be able to, is it 16,000 something? I don't know it off by heart, but yes, it is capped. So if you go onto the government website and look at the redundancy entitlement calculator, that will tell you. But yeah, like the weekly rate is capped, it's also capped at 20 years service. And then after 20 years, there's no more. So yes, it is capped.
Great. Okay, so I think that is all the questions. If we did not manage to cover any of your questions, if we missed them, we do apologise. Like we've said before, feel free to reach out to us either on Facebook or LinkedIn. So you can look me up on LinkedIn, Pritul Khagram at Peopleforce and Kaajal Nathwani at Curwens. You'll be able to find us, and feel free to reach out to us anytime. That's it from us. Thank you very much for having us.
Pritul, just before you sign off, so the cap is 16,140. So I knew it was somewhere around 16,000.
Okay.
Thanks.
Thank you very much.
Well, thank you to Pritul and Kaajal. I'm Lena Sodha, and I just wanted to say a final few words on behalf of the LPN committee. First and foremost, I think it goes without saying that we'd like to say a special thank you to our two presenters and speakers for the evening, Pritul and Kaajal. Of course, you've shared some insight and expertise with us on HR, furlough, redundancy that I sure didn't know about. And I feel enlightened, so thank you. I know my rights now, and I'm sure many are in the same boat, so we cannot thank you enough. I think secondly, we'd also like to say thank you to our audience and to everyone who's tuned in. You know, you guys have taken time out of your busy diaries to tune in and support us. And of course, you know, that is really important, and we are here to listen to you and take on board your comments and suggestions for future events, because it is all about moving forward together. If you do have any suggestions, comments, feedback, please do share that with us on our various platforms. And then finally, a piece of good news. So following on from Ronak's presentation last month, we've had a lot of feedback where people have commented that it would be great to learn more about securing our financial future. So we have a future event lined for you next month. We're just finalizing details, so do watch this space. We will be sharing further information with you in the coming weeks, which then leaves me to wish you a fantastic evening, or what's left of it. And I'm sure you're going to digest all the food for thought we've been given this evening. So once again, thank you to our speakers, and we all look forward to seeing you next month. Thank you.